Hi, everybody. Welcome. Thank you so much for joining. We're just going to give a few seconds for people to connect and log on. I'm Lily Manoim. I'm from SALO, the Southern African Liaison Office. Thank you all for being here. And my colleagues, Fozia David and Busisiwe Nxumalo, are going to be co-chairing this meeting. And I'm going to hand over to you, Fozia.
Apologies. Thank you. Good morning, everyone. And thank you for making time today. We've got quite a diverse audience with us, and thank you for making the time. So just to maybe do some housekeeping, the session is recorded and will be live streamed as it is a public dialogue. So it is being live streamed on our Facebook page. And so maybe if I can jump right in. So it's really a great pleasure to welcome you to our SALO dialogue on migrant policy changes in South Africa. And today's dialogue comes at quite an important moment as South Africa's migrant or migration policy landscape is undergoing significant changes. So with the release of the white paper on citizenship, immigration, and refugee protections, so towards a complete overhaul of the migration system in South Africa, which is alongside the Immigration Amendment Bill of 2020-2024, we're witnessing significant shifts in the approach to migrant governance, citizenship, and refugee protection. Our goal this morning is to facilitate a thoughtful and evidence-based conversation on the proposed changes, to explore potential strengths and weaknesses, and then to also understand what are the broader implications for human rights, regional cooperation, and then also the future for South Africa's immigration framework. We are especially honored to have with us a panel of experts who will be unpacking these developments. We have Ms. Sihle Nyangiwe, attorney from the Refugee and Migrants Rights Program for Lawyers for Human Rights. And we also have a Mr. Selim Tiane, Chief Director for Policy and Strategic Management at the Department of Home Affairs, and Mr. Alan Hirsch, a Senior Research Fellow at the leader of Migration Governance Reform Program at the New South Institute. So in terms of some of the dialogue content, this dialogue isn't just an academic conversation. It's anchored in the realities facing millions of migrants, asylum seekers, and refugees currently living in South Africa or seeking entry to South Africa. And so the white paper signals an ambitious overhaul aiming to bring greater coherence, security, and control to migration governance in South Africa. But it also raises significant and important questions that we need to engage with. Will these reforms adequately protect the rights of migrants and asylum seekers? How will the changes to the asylum system and citizenship criteria affect regional migration patterns? To what extent do these policies align with South Africa's constitutional and international obligations? Additionally, the Immigration Amendment Bill of 2024 also proposes a number of legislative revisions that could also redefine the legal landscape for non-nationals in South Africa. So we need to actually consider what is gained and what is potentially lost in this legislative shift. And so through this discussion, we hope to offer constructive insights that can inform policy implementation, legal reform, and then also the broader public discourse. We encourage engagement from all participants, and so please also feel free to share some of your thoughts and questions in the chat throughout the session. Let us now turn to our panelists, Ms. Sihle, who will be going first. Thank you so much for also guiding us through these complex and timely questions.
Thank you so much. I dialogue in this time. So as the speaker said, I am Sihle Nyangiwe from Lawyers for Human Rights. I hope that I am audible and that I'm also visible.
You know,
so
it's not that clear, but with audio.
Just to take you through a quick overview of the white paper, the spread with which this particular paper was drafted, and of course the impact. Thank you so much, as well as statelessness. All right.
Hi, apologies, Sihle. Your audio is a little bit muffled. Maybe if I can ask you to turn off your camera, and so maybe it'll just improve your network a little bit. Thank you.
All right. Please just give me an indication if it's a little bit better now. Otherwise, I'm happy to just hand over to my colleague while I sort that out.
No, it's much better now. Thank you so much.
Okay. Thank you so much for the heads up. So let me just quick you like a quick overview of the white paper, the spirit with which it was actually drafted, and the kind of impact that it will likely have on citizenship, access to nationality, and just the overall migration system in the country. So in the introduction of the white paper, the Department of Home Affairs acknowledges that the migration policy in this particular country should be informed by the idea of Pan-Africanism and by extension the idea of African Renaissance. However, even though in theory this is in fact a welcomed approach, but you'll find that the white paper is incompatible with the ideology of Pan-Africanism and is therefore not fit for purpose. So what we see reflected in the white paper and the general trend, not only in the Southern African community, but also globally and further afield, is an increasing trend to frame migration through security measures and to protect the so-called citizenry circle. This particular shift isn't only reflected in the white paper, but more broadly speaking in migration channels all over the country, all over the world, in fact. So it is the idea of shifting from regularizing migration and reaping the benefits of migration and also framing it as a security threat or security concern that requires mitigation and restriction. So, like I said, this particular shift is aptly captured and reflected in the white paper and also seeks to limit the country's protection obligation under both international as well as domestic law. And of course, it does this in a number of areas, from birth registration, which is an essential administrative tool that affirms one's existence and communication with the outside world. It also does this through controlling the pathways to citizenship for children born to citizens or to people born in the Republic of South Africa who would otherwise be stateless, to of course completely blocking access to the asylum system, which of course is required to administer it in terms of both domestic as well as international law. So currently the white paper is completely untenable and also completely unworkable. All right, then I want to zone in a little bit on the idea of Pan-Africanism so that we're able to understand then the framing of the white paper. So Pan-Africanism is an ideology that has undergone evolution over multiple centuries and decades. Of course, the great architect Thabo Mbeki has also been lauded as a person who's able to develop this ideology to what it actually is today. So essentially, when you break it down, it is a belief that is premised on equal rights and the advancement of the African continent and working towards self-determination and also unity as well. And so SA immigration policy falls short of realizing this particular ideal and actually masks behind restricting access to protection and also restricting access to citizenship and documentation. Then when you have a look at the spirit that underpins the white paper, it is actually underpinned by a misconstrued belief rather, that asylum seekers, refugees, and migrants can acquire legal statuses, documentation, and even citizenship too easily, and seeks to monitor and also diminish fundamental rights and protections, whereas in reality, hundreds and hundreds of citizens and even non-citizens alike struggle on a daily basis to be able to affirm their rights to dignity because they lack a fundamental pool of rights, which can only be realized through the issuing of documentation and the recognition of citizenship. And so the white paper fails to acknowledge the country's failure in addressing issues of inequality and poverty and unemployment, and instead blames the influx of migrants into the country for its failure to deliver on its core constitutional mandate as well as service delivery as well. The white paper also fails to note the Department of Home Affairs' failure to comply with numerous court orders to establish clear and transparent policies and procedures to be communicated to local officers, and also a failure to render effective service delivery to the public. All right. The white paper is also silent on the root causes of the challenges that the Department of Home Affairs is currently facing, and also fails to provide evidence of the proposed solutions. It rings hollow. It is also a refusal to take accountability and erodes constitutional principles and standards. And so by hiding the idea of disharmonization between the legal and the policy framework, instead of actually addressing unlawful or the implementation of the policies, which have also been exacerbated by corruption. And then lastly, in terms of the underpinnings and the general overview of the white paper, it also then fails to take into account the report of the Lubisi finding, which was published back in June of 2022, which found that the Department of Home Affairs actually operates with inadequate systems, communications, and operations driven by budget constraints and corruption, outdated system, and a trend to circumvent the immigration laws of the country. And so, briefly, the white paper seeks to limit protection to the country's fundamental rights and services by calling for a complete overhaul of the country's Refugees Act, the Citizenship Act, as well as the Immigration Act. It blames the crisis mode in which it finds itself in on disharmonization. But really the root cause actually is lack of proper implementation of existing laws, but also lack of proper and clear transparent procedures, as well as realizing the rights to administration, fair administrative processes. I'm going to move on to some of the weaknesses that we've seen in the white paper and the impact then that it will have on the realization of the right to nationality, and the impact that it will definitely have in increasing statelessness and persons then who are also at risk of being stateless. So the white paper specifically is modeled on narrowing access to citizenship and is also informed by an unsubstantiated claim that citizenship is granted too easily to refugees as well as asylum seekers. So this particular claim isn't only unsubstantiated, but it is also false, considering the fact that only 0.2% of the total population has obtained citizenship by way of naturalization. So the white paper then proposes to do away with Section 4.3 of the Citizenship Act, which grants eligible applicants who are born in the country and have lived in the country from birth up until majority the right to apply for citizenship if they were born to other categories of migrants, including undocumented parents, those who are stateless, or those who have an irregular immigration status. Now, Section 4.3 is a crucial safeguard against statelessness. Not only Section 4.3 in terms of the Citizenship Act, but there are also other important provisions which the white paper actually seeks to negate, such as the Section 2.2, which is a pathway to citizenship for persons who are born in the country but would otherwise actually be born stateless. So this particular shift isn't only regressive and increases exclusion, but also will fuel discrimination, given the fact that most of our clients and most of the people that access this particular pathways are a particularly vulnerable group of children and young people who are otherwise stateless or at least at risk of being stateless. And so the only pathway to access documentation is through these particular provisions in the Act. And if those particular provisions then are limited or restricted in any way, in any fashion or shape or form, then you inevitably have then exclusion and discrimination. And so our particular clients, which is a vulnerable group, refugee, asylum seekers, stateless persons, etc., with no other legal and social connection to any other country, because they're born in the country to Black migrants who were historically excluded from regular migration processes. So the white paper then further entrenches that racist effect of our past and refuses to, acknowledge, but also realize the idea of Pan-Africanism. All right, so the failure to get clarity on the processes of citizenship applications or to get their citizenship application process within reasonable time has left them in a limbo and has also severely prejudiced their lives. It has significantly affected their rights to be able to access basic fundamental rights, including the rights to healthcare, the right to education, the right to access social assistance, employment opportunities, freedom of movement, and of course to foster a sense of belonging and identity. Excuse me. And so once again, what we see reflected in the white paper is this constant blame on the difficulty implementing the Citizenship Act, on the lack of harmony between these pieces of legislation compared to the other piece of legislation. But actually, in reality, it is fueled by a failure to promulgate regulations in terms of the Act, specifically in respect of the otherwise stateless provisions that we see in the Citizenship Act. So currently, the Department of Home has also failed to implement or to establish a nationality or even a statelessness determination procedure, with no regulations, no prescribed forms, and no prescribed offices of application. And so overall, the white paper is aimed at two things. It is to restrict pathways to citizenship, to regularization, and access to documentation for asylum seekers, refugees, migrants, and stateless persons, and of course, narrow access to fundamental rights such as education and healthcare, which are both fundamental but also intrinsic as well. All right, then moving on to some of the weaknesses of the white paper as I'm about to conclude. What we see as a major flaw in the white paper is the proposal to limit birth registration and make it dependent on the lawful presence of the parents in the country. Now, this is a violation of a number of principles, not only the paramount principle, which is embedded in the Children's Act and also in the Constitution as well, but also leads to deprivation of nationality, especially for persons who would otherwise be stateless who were born to stateless parents. So another threat, another weakness in the white paper is, of course, the proposal to abolish and to completely overhaul Section 4.3 on the pretext that there are other visas that applicants can be able to avail themselves to, including children born to asylum seekers and refugees who are unable to seek consular services. Now, this particular tag would, of course, then exacerbate the issue of statelessness in the country and, of course, then increase the vulnerability of orphaned and abandoned children. And once again, this shift towards protecting the citizenry circle, which is also regressive as well. All right. Now, the white paper, even though definitely not fit for purpose, but it does also provide for some, should I say, improvements in the immigration system, and if properly monitored and properly implemented, could be able to bring about some welcome change. For an example, this is the recognition that our duty bearers, our refugee status dissemination officers, are simply not equipped to be able to handle the complex issues of migration. There should actually be a move to be able to hire highly qualified or retired judges to be able to chair the Department of Home Affairs appeals bodies. So this is a welcome change because we believe it will definitely be able to aid in the implementation of fair processes, in the provision of adequate reasons and recourse, representation, and of course also bolster service delivery as well. It will also then improve public confidence in state bodies. It will also be able to increase access to services as well as freedoms as well. The integration of technology tools like the move towards virtual hearings will also alleviate the backlog that exists not only in birth registration, but also in the asylum system, in the internal appeal and review bodies. It will also then reduce corruption and expedite the application processes. The introduction of immigration courts for the purpose of reviewing the decisions of the Director General, the Minister of Home Affairs, will definitely be able to accelerate and this as well. And so the white paper in its current form will not technically fit for purpose, but also falls foul of the idea of Pan-Africanism. If implemented properly in respect of their strength and maximizes the strength that it actually proposes, then it can be able to alleviate some of the challenges that the country is actually facing, particularly issues of migration, statelessness, and citizenship. And so in conclusion, the crucial safeguards, the legal safeguards that we have in the Citizenship Act and the Refugees Act, specifically the principle of non-refoulement for persons who are in this country who have sought protection and refuge in this particular country. These particular freedoms, these particular safeguards should never actually be tampered with. Because they provide important protections for particularly vulnerable groups like unaccompanied and separate and orphaned migrant children. The Department of Home Affairs should be able to move towards the idea of Pan-Africanism and include the citizen circle instead of promoting and inclusion, and be able to adopt a people-centered and a human rights-centered approach to migration in South Africa. Thank you so much. I'm handing it back to the panel.
Thank you, Sitwe. I think you raised a number of very important issues. I think touching on, the first issue around the securitization of migration, and I think that was quite insightful. I think your point on that is especially important because what we're witnessing is not only in South Africa, but globally, there's a shift in the discourse around migration, where it is increasingly framed as a security threat rather than a developmental or human rights issue. And so it's critical that we actually interrogate what this means for vulnerable groups, particularly for those who are seeking asylum, and how it affects public perception and ultimately policy implementation. And I think that that pathway, specifically in South Africa, we can see migration is increasingly being viewed as a security threat, and it does have consequences for policy implementation. And you raised the point on children and statelessness. I think this is a vital point, about pathways to citizenship for children who would otherwise be rendered stateless. And so it is worrying. And so I think it would be important to understand what the proposed controls in the white paper are that may risk narrowing access to legal identity and protection for children born in South Africa to non-national parents. So I think it is important that we engage in this, and where the constitutional right to citizenship isn't undermined in practice. And then you also raised an important point on transparency and due process. And so transparency and fairness in the procedures leading to citizenship. And so I think we do then need to understand whether the white paper aims to create a robust and efficient system, but then also in parallel to that, we also need to ensure that the systems are quite clear, accessible, and then also uphold the rights of those within the system. And so we need to understand where we're falling short, and so what interventions need to be undertaken then to ensure that that gap is mitigated. So thank you so much. So I will then hand over to our next speaker, Mr. Sitlem Ntiana, the Chief Director for Policy and Strategic Management at the Department of Home Affairs, who can then perhaps shed light on some of the points raised by Ms. Sitlem Nyangiwe, and so to also help us better understand what are some of the underpinnings of the white paper, and then what are the implications thereof. Thank you so much.
No, thank you very much, colleagues. I'm trying to check if I'm audible enough.
Perfect. We can hear you.
All right, great. No, thank you very much for this opportunity for engaging with the civil society, colleagues, friends, and associates on a very, very exciting yet very difficult topic that we are dealing with today on migration, citizenship, as well as civil registration. So I see there's quite a few of people who are here. I don't want this to be like a dialogue between us and my namesake, Sihle. But I just want to give you a teaser in terms of what is coming up. Maybe let's start with the critique that my colleague has made on the white paper that was approved by Cabinet in 2024. I think it's very important. Context is important now as we're discussing this paper now. When the paper was approved, it was the previous government, the sixth administration. Immediately in June, GNU was installed. When it was installed with the new priorities. So the new minister coming in had to be briefed on the paper that had been approved by Cabinet, and then the need to align the paper that was approved by Cabinet with the new priorities of the government of national unity then became a necessity. So then what we decided at a departmental level through the guidance of the minister was to start a process of reviewing the then white paper. That is the white paper that my colleague was speaking to. So we are at an advanced stage now in terms of revising the white paper. We should be gazetting it for public comments in the third quarter, that is around October or so for public comments. So there will be another opportunity to engage on the white paper. But by and large, what the white paper is trying to do is what other countries are doing as well, to decide which migrants do you want to attract to your country in terms of skills, in terms of investment, as well in terms of international protection. So let me start with citizenship. Citizenship in most countries is by blood, meaning one of the parents must be a citizen for you to qualify for citizenship. And it doesn't matter where you are born in the country, whether you're born in the world, whether it's in the country or in other countries, as long as one of your parents is a citizen, you become a citizen automatically. Other routes to citizenship is through naturalization or is through adoption. Those are the routes that you have. The other one that my colleague touched on is when a child becomes a major, then the child qualifies to apply for citizenship. Those are the routes that are there. So the law has not changed. So that's what remains. What now the white paper recommends, I won't go into detail to the revised white paper because the minister must pronounce on that before we can start engaging with the public. But we are recommending that you have to have clear pathways to citizenship, have a clear pathway for those who are through the economic stream, those who are investing, who have skills. You have a particular pathway for that. Then you have a particular pathway for those who are on the non-economic stream, which it's something that is still subject for further approval by the minister. We recently had a meeting with the Immigration Advisory Board where we presented this new ideas, and the advisory board is seized with that issue. So that is the part with regard to citizenship, without going into details around that. But it remains our main focus that you have to protect citizenship. It's what we want to do. It's what other countries want to do. We want to open it to those who are contributing to the country. We also still want to open citizenship to refugees, those who are in need of support. But the conditions, they will not be the same. For instance, if I make an example, the number of years that you are spending in the country will not now be the main reason why you qualify to become a citizen. There will be other grounds. We are also going to introduce a points-based system, even at a citizenship level. We have introduced a points-based system at a visa level for certain categories of migrants in terms of those who have skills by and large. But the points-based system, we are going to roll it out from it at a visa level, at a PR level, at a citizenship level. Qualifications for those visa, PR, citizenship. It depends on the points, and each of points, it's something that the country will still engage with on how do you progress to the next level. So that is citizenship. Then in terms of civil registration, the paper is very clear. It says the universal birth registration. It's the principle that we are adopting across. However, birth registration does not, as it happens in, I think in the US, if you are born in South Africa by foreign parents, you do not automatically become a citizen just because your birth will be registered. So a registration of birth is basically a civil registration function where we are aligning with UN to say we want to eliminate the scandal of invisibility. So we currently, the process for non-citizens is manual. So we want to digitize the process for everyone who's born in South Africa so that we have a record, and the child and the parents have got the record of that child having been born in South Africa. The next area, which is very exciting for me and for most of us in the department, is already the development that are already happening. We're already implementing the white paper in a way in that The points-based system is in the white paper, and that's already we are implementing that. I believe some of you are aware that we have introduced what we call a trusted employer scheme, where certain employers receive preference when they are employing citizens, and if the employers they are looking for meet certain criteria, we don't have to go through a longer process of bring those employees from foreign land. We have a critical skills list which we are using. So it's a combination of the list and the points-based system, especially for skilled migrants. We've also introduced what you call a trusted tour operators. Again, that is assisting the country to attract tourists to come into the country. We also introduced a remote work visa, which allow this is more for nomads, people who are basically knowledge workers by and large. You can come into South Africa while you're employed by your company anywhere in the world. You can spend, I think, up to 6 months in the country. So those exciting things that are happening. We are digitizing the system, like we soon will be introducing the ETA, electronic traveler authorization system, which will replace the e-visa that were rolled out to other countries. So it's quite exciting in that space. The details in terms of the fundamental policy shift, again, even in that space, there are visas that we are going to eliminate. We are doing the overhaul, basically, of the system. There are visas that do not make any sense now. For instance, if we were to look at there's a visa that you have in South Africa. I want to use the correct name in terms of the legislation. In terms of the legislation, that is a net worth visa. Usually people speak about a financial and independent visa. That visa basically says if you have got certain amount of money, you can live in South Africa, can get permanent residence in South Africa without you having to invest any portion of the money. So those are kinds of visas that we want to align and see if we cannot link with other investment visas that you already have in the country. When it comes to the refugee space, which my colleague spoke to that space a lot, the problem that we have in the space, which leads to frustrations sometimes, is I'm not going to dwell on the issue of corruption. I think we all know that SIU, there was a presidential declaration. SIU is working normal affairs to deal with those issues. But suffice to say, despite the corruption issues that have been spoken to by and large, the asylum system is under tremendous pressure. It's being abused by economic migrants, those who are definitely not refugees at all. And some of them, the judgment, when the decision is taken, they go under, they don't come for their decisions. And then it leads to a high number of migrants who become illegal in the country. So that is a very critical space. What we are trying to navigate clearly is when we are trying to deal with the abuse of the system, we must not punish those who are genuine asylum seekers. I think that is not a policy issue, it's the efficiency issue that we are trying to deal with. We are still looking at whether you move centers to the ports of entry. I'm here in Europe, and many countries here that we've gone to, they are doing the same thing. You process your asylum seekers at the point of entry, and you facilitate the process to be quicker. We're still looking at that on how can we apply that principle. First safe country principle here in Europe. they deal with this issue as a unit, 29 countries. They've got the Dublin agreement that they have in place. They're using that, something that we are also looking at. I think by and large, those key issues. I think the issue of the specialized immigration court is something that most people have welcomed, because that will fast track the process of dealing with immigration issues. Something I wanted, what I wanted to mention is we're also working on the future of the Zimbabwean exemption permits, the future of the Lesotho exemption permits, and we are still exploring what could be the medium to long-term solution to those issues. In Lesotho, we've gone an extra mile. I don't know if you are now aware that we've relaxed our movement between RSA and Lesotho. Lesotho and SA citizens, they can live in each country for a period of 90 days per visit, which is something that, in fact, you don't find that anywhere in the world, and that is being applied in Lesotho, because Lesotho is a complete enclave in South Africa. Basically, Lesotho is in the belly of South Africa. I thought I must just touch on those developments. Thank you very much, facilitator.
Thank you so much, Mr. Mtiani. I think thank you also for that points of clarification, especially around the points-based system and the NPR citizenship pathways. I think that is quite detailed, and also how it interfaces with permanent residency and then eventual pathways to citizenship. And I think it is quite helpful to see that there's an alignment with the migration policy, especially with economic development goals. I do wonder also perhaps if there's space for further during the dialogue, whether there'll be engagement around whether there's appeal mechanisms, especially to allow for discretionary nuance within the system, especially if it is on a sort of points-based system, given that, you know, there's sometimes ad hoc cases, and so wanting to understand that approach a little bit better, because noting that sometimes having especially rigid frameworks can also inadvertently exclude otherwise eligible individuals due to technicalities or given procedural inflexibility. Other aspects that you've touched on as well is the notable gains that we're seeing around remote work and investment visas to attach skilled professionals. And I think these are also quite important developments that could inject much needed revenue and innovation into South Africa's economy, especially given the post-pandemic world and issues around labor mobility and digital work. So I think quite an important point raised there. And then I think also noting the point around the pressures within the asylum system in and of itself, that the asylum system is quite overburdened as it stands, and noting that South Africa's position in the region does attract significant migration, and then recognizing that they need some alleviation given the pressures on the system from long-standing backlogs and to reported instances of corruption, which of course is deeply concerning. And then also noting that it's not just a governance issue, but it's actually affecting the lives of people seeking safety and dignity and legal recognition. And then also the other aspect of economic migrants. It's a complex and contentious issue, given that the asylum system is and can be used by individuals that don't meet the legal criteria for refugee status, and having to balance that issue with genuine asylum seeking versus economic migrants. And I think it does speak to a sort of broader question around economic migrants and the sort of difficulty that economic migrants are facing in their home countries, and that sort of driving pressure in the region to South Africa. And perhaps engaging whether there needs to be a differentiated system that does include legal migration pathways for economic migrants, so that the asylum system isn't misused out of genuine desperation. And then also you also touched on reception centers at the ports of entry. I think that is quite an interesting proposal and could use some further unpacking as well during the dialogue. So thank you for those pertinent points. Our next speaker is Alan Hirsch. So I will hand it over to Mr. Hirsch, who comes from, who is a senior research fellow and a leader of the Migration Governance Reform Program at the New South Institute. Thank you so much. Over to you, Mr. Hirsch.
Thank you very much, Fozia. Chair, and first of all, I'd like to congratulate Sihle Mtiani on his participation in this event, and I think what it shows, I think, is the very welcome approach of the Department of Home Affairs, in the current climate, to engage with all kinds of stakeholders about policy development and policy implementation. So thank you, Sihle, and thanks to SALO for organizing this event and for inviting me. I'm very happy to be here. I also want to congratulate, as Fozia has done, the Department of Home Affairs for the considerable achievements that it has had in the last year and a half or so, in a number of important areas, in reducing backlogs, in dealing with corruption, in the implementation of the Border Management Authority and various other really important innovations. So, but there's, we know that there's a very long way to go, and that's why this next version of the white paper is going to be so important. Now, I didn't have access to any of Sihle's, inputs into this conversation before the event, and I was asked to talk about the 2023 white paper, which came out in 2023, which was, I think, approved by Cabinet in early 24. So I'll focus on that. And then there was a piece of legislation we were asked to have a look at as well, a small piece of legislation, but an important one, which I might get to as well. So firstly, I want to make a general point about the 2023-24 white paper, and that is its timing. Firstly, it was a different government, as Sihle has pointed out. Secondly, it came out months before an election. And there was no doubt in anybody's mind that some of the populist parties would take the issue of migration and citizenship and make it a political issue, and they definitely did. It's been catalogued in various areas, but we had members of some political parties marching up and down the Limpopo River in their paramilitary uniforms, really very much a performance with no substance, but it was part of the political campaign, and that must have been in the back of the heads of the minister in writing the statement that he did at the beginning of the white paper. So it was, the political moment was not the ideal moment to launch a white paper. And I think we now are in a much better position, long before the next election, to be able to do something to reflect and develop something that is balanced and satisfactory for our needs. Second point I wanted to make is general point, is that the 2017 white paper, there was a 2017 white paper, which was also approved by government in 2017, which had a number of elements which are not in the 2023 white paper, and the 2023 white paper didn't refer to the 2017 white paper. So I hope that in the process of considering the way forward, that apart from a general conversation such as the department is having with the public now and with the Immigration Advisory Board, that they will also look at the 2017 white paper and some of the elements which, ironically, in fact, the point system was proposed in the 2017 white paper, wasn't included in the 2023 white paper, but it has been implemented. So there may be other elements that are useful in the 2017 white paper that should be considered. Third point I want to make is that this white paper is, it's high level. The way that it's written is very general, and the points that it's made are open to interpretation, and it wasn't accompanied by any draft legislation. So we don't really know what everything in the current white paper means. So we're guessing to some extent what exactly the implications of the words in the white paper are, because we haven't seen a draft law. Also, I think representative maybe of the moment in which the paper came out, the structure is a bit haphazard. The section on safe first country principle, or first safe country principle, should have been in the refugee section, so it was kind of stuck on at the end. So that seemed to suggest that there were last-minute changes made, perhaps at the political level, who knows, that meant that the paper wasn't really complete. There are a lot of things it didn't mention. It didn't mention the issue of corruption, although it did talk about improving the administration of the immigration system and establishing a department or sub-department of immigration within the department. And that was clearly a kind of the inference of that was we have to fix the administration of the immigration section, which I think we all know was, seriously compromised, especially the permitting part of the process. So that's not dealt with in detail, although there was an excellent report that was commissioned by the previous minister in a committee chaired by Cassius Lubisi, that perhaps could be reflected on in the forthcoming report. I think it's necessary to acknowledge that. And a lot of other things not mentioned. The ZEP question, which Sihle raised now, which is a really critical question, and I hope that a fair way is found to deal with both the citizens and the children, the Zimbabwean citizens under the ZEP, and the children of those citizens, many of whom have lived in the country all their lives and are, completing high school at the moment. And we need to find a way to deal with them fairly. So I wanted to just get to a few of the specific issues. On the refugee processes, the idea that, now, as I understood it, and correct me if I'm wrong, Sihle Mtiani, but the way I understood it is that if you are a genuine refugee, you will enter the country through a official port of entry, a designated port of entry, in fact, and you will immediately apply for refugee status. If you enter the country in the other way, and either then try to apply for refugee status, or when you are discovered to be an undocumented migrant, then apply for refugee status, then you will be considered to have entered the country in bad faith and won't be eligible for refugee status. Now it's quite tough. As Sihle said, and as a couple of people have said, this is not actually unique to South Africa. This is something that is being proposed in many countries around the world at the moment. There are a number of problems with it, but one of the things that occurs to me is that how do you deal with these people if you have a huge number of people arriving at, and we probably will continue to have from time to time significant numbers coming. They arrive at the port of entry. They have to be dealt with within a certain period of time. Decisions have to be made within a certain period of time. If those decisions aren't made, what happens to those people? If they're not made within the time required, what happens to those people? Do we have the systems, and when will we have the systems to be able to process them efficiently and fairly under those circumstances? And is there a possibility of artificial intelligence being applied in the process of refugee assessment? And if so, are we sure that the artificial intelligence systems are going to be applied fairly? So those, I think, are some issues that it would be great if we have clarification on in the forthcoming white paper. There are obviously constitutional issues and human rights issues, which I'm not going to address now. There's not time, and that's more for the lawyers for human rights people to deal with. On the citizenship question, it's also, it's incredibly vague, the statement. It's not clear exactly how the changes in the process of application and awarding of citizenship would be made. So we're speculating quite a lot on this. But I guess some key questions are what happens to the children who have been mentioned before, children of undocumented migrants or children of people who've entered under ZEPs or LEPs and who've lived in South Africa all their lives and are now, South African in all but official identity. What happens to them? I think that's a very important question. Another important question, which I didn't see in the white paper, is the question of residential status. How are we going to deal with people who want to apply for permanent residence, but not citizenship? And is that going to be addressed in the next white paper, or is that part of some other process? On the question of the final element, so the three elements in the white paper: refugee management, the refugee management, the citizenship, and immigration management. Most of the changes, I think, as my fellow speakers have mentioned, on immigration management are welcome. The establishment of an immigration advisory board or re-establishment, the new immigration division, the strengthening of the border management agency, which does seem to be in many ways a success so far. But what isn't clear is that there's a reference to in that section of the white paper, there's a reference to the policy will seek to avoid the immigration of foreigners who will adversely impact on existing labor standards and expectations of South African workers. Now, I think that's a reference to economic migrants, whether they are legal or illegal. It's not clear. It's not clear what's meant by adversely impact. And what this brings me to is, what is the relationship between the forthcoming white paper and the National Labor Migration White Paper, which has recently been published by the Department of Employment and Labor, and what is the relationship between them going to be? Because we can't ignore the fact that South Africa has created, since the middle to the late 19th century, a system of dependency between ourselves and some of our neighbors in terms of labor migration into South Africa, Lesotho, Mozambique, and Malawi being the most obvious. And as we all know, the Zamazamas who were found dead in last year's tragedy, they came from those three countries. We have a system of dependency that we have to think about very carefully as we move forward. And I don't really think that the DHA, the Department of Home Affairs white paper, can ignore the labor migration questions and the questions, for example, of our current bilateral labor agreements with 5 of our neighbors. How are we going to move towards a more modern relationship with our neighbors about especially temporary labor migration, which we can't expect will end for a long time. So we have to find our way forward. And there are other parts of the world which do deal with that quite well. On the amendment to the Section 34 of the Immigration Act, that's essentially, it's about the right of the department and its officers, the BMA probably in this case, to detain and hold undocumented migrants for a certain period of time. It's a response to constitutional court judgment. Whether it's constitutional and whether it's fair is something which I think the human rights lawyers would have to engage with. But I think the big question is, can the Home Affairs assure us that this will be implemented fairly and efficiently, that the power of the Border Management Authority and the Home Affairs officials who will be authorizing the detention of undocumented migrants, is that not going to be abused? Is that not going to open new avenues for corruption, and how will it be done in a fair and appropriate way? It does seem to me, and the total number of days that people could be detained for is around about 120 days, which seems like a very long time for people and who could be separated from their families. So I welcome Sihl's statements about this is something of a new start. We are a new government and we're thinking forwards. The old white paper needed a lot of rethinking. If I was working on the white paper, I would start from scratch. There are quite a lot of elements in the existing 2023 and 2020 and 2017 white papers which could be drawn on in the new white paper, but I would start from first principles. What do we want to achieve? What are our main concerns? What do we want to achieve? And how we're going to do it in a way that is fair and within the constitution of our country. And then put together a white paper based on those principles. And including the principle of Pan-Africanism, which the other Sihle, Nyangiwe, talked about earlier today, because that is a very important part. We are in this continent, we are of this continent, we are part of many continental processes and systems, and how do we deal with that? So I hope good luck to the department, good luck to the Immigration Advisory Board, and I hope that there will be further consultations between now and October when the draft white paper is released. Thank you.
Thank you. Thank you so much, Alan, for those insightful comments. My colleague, Brucey, will be just touching on some of the points that you raised, and I'll be handing over to Brucey as chair. So thank you so much. Brucey, over to you.
Thank you very much, Fawzia, and thank you very much, Alan, for that rich input. You touched on some elements that were not fully included in the paper, and you also raised some clarifications and some suggestions of moving forward. We now will be moving on to the second part of the session, which is the Q&A. And what we're going to do is that you may raise your hand using the bottom react sign. You can quickly, briefly introduce yourself and what organization you come from, and then you may ask your question directly. So I'm just going to have a look at the chat box to see the order in which we're going to be engaging the questions. And yeah, so the floor is now open to ask questions directly to the panelists. I'm just going to go according to what is on my screen. You're also welcome to write your question in the chat box if you would like, if you prefer that. So the floor is now open for questions. I just need a minute to look at my screen so I can go. Okay. Any questions? So directly to the panelists. No.
Yeah, maybe. Can I ask a question?
Yes, you may.
Yeah.
You can go first.
I think maybe to balance the two Sihle's questions, given that there were sort of two very different standpoints that's being where the issue is being looked at with Ms. Sihle Nyangiwe was engaging from a sort of human rights perspective, and whereas Mr. Sihle Mtiana is engaging from a sort of state governance and management perspective, and so trying to manage two separate issues. And so I think trying to understand how the white paper balances some of the issues raised by Ms. Sihle Nyangiwe. I'm struggling with the surname, so my apologies, but Nyangiwe. And so how does the paper manage some of those issues raised by Ms. Sihle? So, you know, the pathway to citizenship, especially around statelessness for children, I think that one was quite a big one. So are there any sort of mitigating factors in the white paper that does address this? And then also the other issue that's faced by migrants around asylum seekers and the actual backlog of the process. How will the white paper sort of support the expedite of that backlog, because I think there's probably thousands of persons stuck in the system that doesn't really have a way forward. So they are in the country illegally, but given the sort of bureaucratic backlog, what are some of the sort of processes that will be instituted to address and fast track that issue? Thank you.
Thank you very much, Fozia. Just to say that you don't also have to only ask questions, you can also give an input or direct response to what the speakers have said. I do now see a second hand. Lauren, you may come in to introduce yourself quickly and then pose your question. Thank you.
Great, thank you. Thank you for everyone for organizing this. My name is Lauren Land. I'm with Wits University. It's a question really for the second Sihle, but let me preface it by saying I appreciate you coming. I know that immigration policy and trying to navigate this is like being between a rock and a hard place with people also sticking you from the side. So really admire your willingness to face this group. My question is building a little bit on what Alan suggested and others, that the white paper as it now stands, and I know it's being revised, but is based on a series of presumptions, but also a lot of research that is empirically questionable. It's sort of handpicked to demonstrate a certain type of perspective, the securitization perspective that the first Sihle spoke about, but also make some rather broad claims and unsubstantiated claims about the effect of immigration on crime, on the economy, etc. So I'm wondering what can be done or what will be done to ensure that the new white paper is based on a broader range of empirical research, not just kind of political principles. And perhaps more importantly, what can be done to ensure that the policies that are ultimately implemented are monitored and assessed? Because I sense that we're looking around the world and saying, look, England is doing this, the UK is doing this, but we're not looking around at what those policies have done and whether they've actually worked to deliver for the citizens and the immigrants in their country. So I'm hoping, maybe you can tell us whether there will be a monitoring process about whether the migration laws, the labor laws, etc., will actually work, and whether they will be based on empirical foundations or speculative sort of accounts of what's going on in the country. Thank you.
Thank you very much, Lauren. I'm just going to read out loud what is written in the chat. Then I'm going to go in the order of taking the hand of Sharon and Gabby. So the first point is that for Majotsi, it says there seems to be confusion on which system is being used. So this is to the department. Is the point system being applied currently? Then the second question is also to the department. It asks that, has the Department of Home Affairs considered asylum seekers and refugees of people persecuted based on their sexual orientation and gender? There's another one from Mellon, which says, can the policies that promote both inclusive urban planning and migrants help mitigate the adverse effects of gentrification while fostering social cohesion? So those are the questions posted in the chat. And then I'm going to move on to you, Sharon, and then take Gabby, and then come back to the speakers, and then do a second round. So over to you, Sharon.
Hi, Busisiwe. It's Sharon Ikamvaram, and I work at Lawyers for Human Rights. And good to be chatting with you again, Sihle from DHA, and I want to greet the other panelists as well. Mine is more a contribution, and maybe the panelists can reflect on it if they so wish. I think that what is not being acknowledged is the point that my colleague Sihle mentioned on the positive aspect of the white paper in recognizing the serious problem of the immigration officers being equipped to be able to assess claims and process applications for refugee protection in our country. And so because of that, we have a backlog of, and now the figures have gone up If I'm not mistaken, it's sitting at around 100,000 people or more who have had asylum permits for over 10 to 15 years. Now, these are not economic migrants. We run law clinics, and the clients that we assist and help to take through the appeals process are refugees, whether they come from Gaza, whether they come from Afghanistan, whether they come from the DRC, whether they come from Somalia. And they have been sitting with asylum permits for decades with a system that is dysfunctional. We don't have a mechanism to collect disaggregated data, whether this is to register statelessness in our country. There are no figures for how many people are stateless, and maybe my colleague Sihle can say what the estimates are and how serious that issue is, not only in South Africa, but in the region as well. And then I do think we cannot just brush over the issue of corruption. In every submission that civil society has made, including Lawyers for Human Rights, we have raised, whether it was the green paper on migration, whether it was the white paper on international migration in 2017, I think it was, one of the speakers mentioned it, and the one that we're discussing today, we spoke about the need for a concerted effort and a plan by the Department of Home Affairs to deal with and root out corruption, because it has become part of the system. And the people are struggling to get access. They cannot get documented. And as a result, that makes them prime targets for what amounts to racial profiling, when darker-skinned Black African brothers and sisters from the continent are targeted under the suspicion that they're undocumented and can then have bribes solicited from them. And this becomes a vicious cycle that is, they suffer from both immigration officers and from the police, which has then resulted in the criminalization of movement of people and migration. And, you know, it's unconstitutional. The ethos of our constitution is respect for dignity of all who live in this country, and especially given what's happened in our past. And so I think that, you know, that's the context within which our immigration and our policies around management of movement of people must be located. And for me, it does require an overhaul. But I have to say, I do welcome the refreshing reflections and comments by Sihle as a representative of the Department of Home Affairs, and in particular to underscore the point that Alan has already made of the openness to engage with civil society, because we have, you know, it's been a really closed door of engagement with the department in the best interest of the most vulnerable in our region. And I think, you know, the last point I want to make is that this question of the engagement with our neighboring countries is a critical one. People are forced to be undocumented. Can you imagine in Zimbabwe, how does with 90% unemployment or some unbelievable figure like that someone has to pay $250 for a passport? And so when they come to South Africa, then they're arrested for being undocumented because their passports have expired, because they can't afford to renew their or get a replacement. It's completely impossible to make that money. So our government and the DHA should be engaging with DIRCO, and how do we engage with SADC to address these problems, which force people, because of poverty and inequality in our region, located in our past of colonization and apartheid in our context, that you know, they remain undocumented. And the center of this point is the indignity that poor people suffer If you're rich, as was pointed out in the visa net worth, that's how the Guptas were able to come into our country and get permanent residence within 6 years. So I think the class cannot not be a factor in our discussion around our policies on movement of people in this region, and then located in the context of the continent and the conflicts that are going on for over decades, and how that impacts on people leaving their countries and not being able to go back because of the extended periods of conflicts that they're experiencing. Thank you.
Thank you very much, Sharon. I am going to now give to Gabi, and then we'll take it back to our speakers. So over to you, Gabi. Gabi, are you able to unmute?
Oh, yes, thanks. Yeah, thanks for the opportunity. Just a short question to the Home Affairs guy. I think he's also Sihle. He spoke about new asylum seekers reporting to the port of entry. My question is, what about those who are already in the country? Because at the moment, the Home Affairs officers, the refugee reception officers, are not accepting newcomers if they don't have the Section 23. So what exactly is it? What is the plan about those who are already in the country? Should they be advised to go back to the port of entry? What is the view about them? Because they are considered illegal or undocumented, yet they have genuine asylum application issues, so they're not economic migrants. That was my question. Thank you.
Thank you very much, Gabi. What we're going to do is we're going to go with Mr. Sihle from the Department of Home Affairs to answer first, and then we're going to go to Sihle from the program at Lawyers of Human Rights, and then we're going to go to Alan. So in that order, you may go. Over to you.
Thank you very much. It's quite a lot for me to respond to, but let me try. I think just to respond to the comment that was made by the last speaker. Though this is still an issue that is being dealt with by various courts, I think for those who are in the refugee space, you will be aware of the Ashebo judgment. Basically, I think Alan, you also raised the issue there. The Ashebo judgment doesn't say asylum seekers should not be allowed to apply for asylum when they have entered the country illegally. But what the judgment is speaking about is they must provide a good cause on why they entered the country illegally. I'm not going to go into the details on how is it being applied, that principle now, because it's something that it's sub judice. But we are not, and we cannot refuse asylum seekers the right to apply for asylum in terms of the law. Number two, what I wanted to mention is, in terms of the convention, I think it's Article 1F. Pardon me if I'm quoting it the wrong article, but I think the most important thing there is an asylum seeker from Zimbabwe or from our immediate neighboring countries, it can be accepted if they enter the country illegally, because they could be running from direct danger from those countries. But a person who's traveling from other countries to enter the country illegally, that person ought to provide the good cause. Why did he or she have to enter the country illegally? I think that is it's clear, and it's the principle that is applied in various countries. That I must clear that one first. So I am not aware. The previous speaker says we do not allow asylum seekers to apply for asylum. We've got centers which are open, like from almost said Maseru, from Messina, in Pretoria, Cape Town, the East London, and then Durban. Those are open for application. We can speak offline. I think my email is available if there are any other issues. There's a speaker also spoke about granting of asylum on the basis of sexual orientation, gender, and all that. We do. We apply we look at the refugee definition as per the convention. We do not limit it. Anyway, member states are not allowed to redefine what a refugee is. So we apply the principle as is. I agree, Sharon. The issue of corruption is something that we cannot underestimate and take for granted. As I was saying earlier on, the previous minister realizing how bad it was, then approached the president. As a result, SIU then started to work. So we're still awaiting the report on that. And also, I think Alan Hesh, you mentioned the work that was done by the previous DG in the presidency, which also that work came up with recommendations. There are officials, as you will know, that have since been fired in the department. There are officials, I think, every month, almost every weekend, which is possible. There are officials which are appearing to courts. Some of them have already been charged. Some of them are already in prison. So there's quite a lot of work that the department is doing in that space. And clearly, that has got impact on service delivery, whether you are talking in terms of our citizens, of non-citizens. It is a reality. So it's not something that we will want to take for granted. Then on the issue of, look, it's a pity I can't share more, and I think colleagues will understand until our political principals have cleared the paper. But I can say there's quite a lot of revision that we've done on the white paper, and also the arguments. We've tried to be clear on the arguments on why we are taking a particular position, but it's a pretty balanced white paper. Maybe it suffices to say, when Cabinet approved the white paper in April last year, there was a proviso that we must also do a legal opinion on certain provisions of the white paper. We've done that, and the white paper takes into consideration some like not some, takes into consideration the legal opinion that we have received. So we started by saying we are doing a supplementary policy paper, but we realized that we are not supplementing some of the provisions in the white paper. We are actually rewriting some of them, given, as I was saying, the new priorities of the new government, as well as the outcome of the legal opinion. I think it was Landau also mentioned the issue of an evidence-based policy. So it's in different ways how we're looking at the policy. Firstly, we have looked at different policy directions internationally. It's difficult at this point to look at what is the impact of those changes, because some of the changes in EU, they are quite new. So, but time will tell. We have an M&E unit and a research unit in my section that will be seized with that work. And we will welcome Landau working with various institutions of higher education, including yourself, Alan. That will be helpful so that we come up with a policy document that is well grounded on evidence. Now, Alan, you raised an issue around the alignment between this work and the work that the Department of Labor is doing. The Department of Labor is what do you call it, is the custodian of labor market policies. So they determine the policies in that space. Home Affairs issue visas based on what the labor market is guiding us to do. So we are not the first line policy department when it comes to labor issues. In fact, in all issues, when it comes to tourism, when it comes to trade, when it comes to business, when it comes to labor, when it comes to security issues, Home Affairs plays a secondary policy role when it comes to that. So we are working together with the Department of Labor. However, I want to mention that as is the case with the critical skills visa, all the qualifications, occupations that are already listed as in demand, those kinds of qualification won't be subjected to the labor process as alluded to by the previous speaker on the issue of the points-based system as well. The points-based system as well, what we are adopting at the current moment, we are cutting off the what you call this, but the process where labor must certify that there is no South African or there is no PR holder who is who can do the work. These are skilled people. In fact, in future, the consideration is to drop the list, because once you've got the points-based system, the market will determine what are the needs of the market. But that is the future that you are looking at. Chair, there's quite a few issues that have been raised by colleagues in this platform, but I think we'll be having more or better engagement once the minister and cabinet have approved the amended white paper for public comments. I must say, when those who have been part of drafting policy, it's very difficult to satisfy everyone. But the bottom line in terms of the policy work and legal work that we do, if it is declared by the Constitutional Court as unconstitutional, it's something that we will not implement. Then just to touch base on the immigration amendment bill is in Parliament. Basically, it's just a small amendment. It's Section 34 of the Immigration Act that is being amended. Basically, the Constitutional Court declared that provision as unconstitutional because those who were being deported were not appearing before the magistrate. So I think I can end there, Chair. Thank you very much.
Thank you very much, Sihle. We're going to now hand over to the other Sihle. Sorry, you may come in from the.
All right. Thank you so much.
Sorry, is that other Sihle?
Yes, other Sihle, then we'll come to you, Alan, afterwards.
Thank you, Busisiwe, and thank you to my namesake as well for that very comprehensive response. I just also want to give thanks to the audience for engaging with us fruitfully on this important matter. So mine is just mainly to reflect on the contributions that have been raised from the floor. I want to start off by just amplifying the contribution that was made by Sharon on the issue of poor decision making, and also to amplify that, and also just to impress upon the Department of Home Affairs that really there can be no real realization of the vision in the Bill of Rights, or even in the Freedom Charter for that matter, without fair administrative processes in place and ultimately leading to administrative justice. Now, the issue of administrative justice, which includes, issues of rationality and due process, and objective access to information, was also made reference to in the Mazibuko case, which dealt with the unlawful practice of ID blocking as well. And so the white paper, while acknowledging the issue of poor decision making among, refugee status determination officer, and many of these decisions having to go to the internal appeal and review bodies, is unfortunately silent.
Sorry, Sihle, I'm sorry to cut you. Please may you try to come closer to the mic. People are struggling to hear you, if it's possible.
All right, I have just moved it closer to me. I'm not sure if it's sounding a little bit better.
Okay, you may continue. Apologies about that.
Not a problem. So the issue of poor decision making, and ultimately that being then a barrier to accessing administrative justice, is also indicative in that the white paper fails to acknowledge then the issue of deprivation of citizenship through the unlawful practice then of blocking people's ID, but also the refusal then to issue IDs to first-time ID applicants. Again, in line with the issue of shrinking of protection, not only impacting non-citizens, but also those people who have a legitimate claim to South African citizenship. On the issue of refugee reception offices, and my namesake not being aware of the practices on the ground. So currently these refugee reception offices, specifically the ones in KwaZulu-Natal, are not administering new asylum applications, and there's been no real update on the part of the department on how far they have come in addressing or perhaps even alleviating the backlog in the internal appeal and review bodies as well. Then I also just want to, as a parting shot, and respond to the contributions that have been made, but also to congratulate the Department of Home Affairs in the decision to include naturalized citizens and permanent resident holders in the rolling out of the smart ID cards. We believe that such a move will definitely be able to enhance inclusion, but also the move towards people-centered approaches, but also infusing human rights-centric approaches, and also enhance service delivery as well. And so those are my immediate response and contributions and reflections to the panel. Thanks.
Thank you. Thank you very much. Over to you, Alan.
Okay, thank you, Busisiwe. I want to pick up a question that appears in the chat. There's a question about urban housing, gentrification, and so on, which I think raises the very important question of housing in general. And I think the purpose behind the question was to say that there are some migrants who are well-off migrants who are raising property prices in South Africa. And because housing is by no means unlimited, the prices are going up and it's becoming inaccessible to many people, urban housing, proper urban housing. So that's the one side of the story. The other side of the story, which I don't think was intended, but I want to mention it as well, is that the current, and I think the correct and humane policy of the government and of the existing Refugee Act is not to have encampment as a requirement of people who are in pending refugee status or refugees who don't have their own means. refugees and people pending refugee status are generally expected to find their own accommodation unless they choose to be in a camp, which is, not most people wouldn't do that. So, I think that what that brings me to is the issue that access to housing is one of the issues which has fueled the right-wing populist, and left-wing, in fact, populist anti-migrant feelings around the world. There are a number of countries where housing prices have gone up quite dramatically. Housing stock is limited for various reasons. And there is a risk that if we don't deal with this question properly, that will fuel our own, the sort of more irrational part of our anti-migrant responses that Sihle has to deal with. Clearly Sihle can't please everybody, and I don't think it would be futile to try to, but to find that balance, which he also referred to. He has to deal with those kinds of people. So I think that we do have to deal with this question of housing. The fact is that in Cape Town, where housing prices have gone up the most of the immigrants are immigrants from other parts of South Africa. It's got nothing to do with international immigration. So it's not relevant to talk about it here, but what is relevant is the question of housing development. And I think that the Home Affairs should engage with their colleagues on that question. But it brings me to one final point on that question, and that is the question of inclusion. Where most of the poorer end of the migrants, the refugees and the people who are pending refugee status, who've applied for refugee status, they tend to live in informal settlements and poor urban areas. And they inevitably, in some areas, are seen as competition for resources. And part of the reason for that is that there are limited resources. And that's not because mostly of the migrants, it's more because we've had no economic growth and very little investment in social infrastructure for a long time. But why it's an issue for the Home Affairs is, are we thinking about the question of inclusion? Are we including the question, in fact, in our white paper of how we're going to find a way to build bridges between South Africans and migrants, so that those and the migrants who are legal in one way or another, and those undocumented migrants, obviously, where they slip through the net. Are we going to be able to build bridges and build understanding? And to what extent is that the Department of Home Affairs issue, that they should be engaged with the question of managing inclusion processes, or at least supervising inclusion processes, many of which would happen at the municipal level? Thank you.
Thank you very much, Alan. We're now going to be taking the last round of questions or inputs, and then we're going to give it back to the speakers to do some parting shots before we do some closing remarks. Just looking at my screen to check if there are any last questions. Okay, I don't see a hand up, but I do see a okay, they're in the chat. I'm just going to quickly read out the chat, and then I'm going to go back to see if there's any hands up. So one is from Lauren, who says, thank you, Sihle. If there's any way we can support the policy formulation or monitor and evaluate the process, please can you let them know? There's another question that says, partnership is certainly key when it comes to addressing issues related to migration, in particular when it comes to asylum seekers and refugees. A question to Mtiane is, are we refining the process, or will there be greater partnership with bodies such as the United Nations Human Rights Commission? And is this partnership also much more potential when it comes to the data which has been shared out by Sharon? And this is a very major and vulnerable issue, as it holds so much promise in improving the process. The second question is that it's to the rest of the panel. in your own opinion, is there any way that there's an effect of the withdrawal of the US aid and the changes made to the US refugee admissions program? And there's another comment from Melon that says, thank you so much, Alan, for your response. The issue of leaving no one behind and fostering inclusion is inseparable when discussing migration, especially on the context of bridging connections with local communities. And they do appreciate your engagement on this matter. That is from Melon from the UNDP. I don't see any hands at the moment. So what I'm going to do is give each speaker to either respond to what has been written in the chat, as well as giving you a closing shot before we head to the closing remarks. So I'm going to go back in the same order again. I'm going to start with Sihle from the Department of Home Affairs, and then I'm going to move on to Sihle from the Attorney from Refugees and Migrants and Human Rights, and then with Alan. So in that order, you may, over to you, Mr. Sihle from Department of Home Affairs.
No, thank you very much to SALO for hosting this, and to my fellow colleagues, panelists that have been here. Most definitely, Prof. Landa will need to engage further. I think we, as well as Alan and other academics as well, as soon as this work goes public, I think we can do quite a lot of webinars, roundtables on various issues, so that by the time we finish with the paper, it's also a point that was made by our minister when he joined the department, that we must make sure that we embed this policy work on evidence. So yes, we will take, we'll appreciate that engagement, colleagues. The department is working very closely. Let me not just single one UN agency, but with all UN agencies that are based in South Africa. We've got some engagement that are happening at a policy level. UNHCR in particular, they are working with us very closely in dealing with the issue of what do you call the backlog? Sorry, the backlog. They have committed some resources to that effect. So we look forward to seeing the numbers of the backlog applications going down. I think, Alan, the issue of being inclusive, it's something that we've tried and will continue doing that. At some point, we're trying to work on the integration policy for migrants. That work, we're working together with local government, human settlement, and other departments, including social development. So we will find a way of resuscitating that work. But when protection is provided to, especially when a person is a refugee, it's inclusive, it's a package. You cannot exclude refugees in terms of that. There was a point raised now, it escapes me, but we can always engage offline, me and you, on any other issue that you might have raised. But we really appreciate the opportunity. We will avail ourselves to engage on this work. Or the point that you raised, Alan, was around indeed, I just want to confirm, we are not the policy is not gonna change in any way to start the refugee camps. Refugee camps, as we've seen internationally, they're inhumane, expensive to run. They've got all sorts of problems, irrespective of what our constitution says in terms of freedom of movement. But refugee camps generally are very inhumane. Thank you very much.
Thank you very much. We're now going to move on to Sihle from Okay, you may unmute.
All right. Thank you, Busisiwe, and thank you to Mr. Mtiani for those parting shot. On the issue of withdrawal, so the withdrawal has had a very big and a significant impact in terms of civil society's ability to be able to provide either direct or indirect legal and social assistance to the refugee community, due to budget cuts and of course funding constraints as well. So the programs as well. And so for as long as civil society is severely affected, it means that the vulnerable groups will be even more affected, because that is actually where they seek refuge to be able to enforce their human rights, but also to affirm dignity as well. And in closing, just impress upon not only the panelists, but also on members of the plenary as well, to say that migration can be crafted in a manner that enhances human rights, in a manner that is reflective of, but also involves technical barriers and difficulties that are bureaucratic in nature, but are completely solvable as well. And also just want to give my thanks to the Department of Home Affairs for being transparent, and also for taking the opportunity to engage with us, even on such a platform. Thank you.
Thank you very much, Sihle. Alan?
Thank you, Busisiwe. Yeah, thank you very much to SALO, to the chairs, to my fellow panelists, and all the people who participated in this important and valuable conversation. And I hope that these conversations continue. It's a really great opportunity for accountable governments and open government, which we hope will always be a feature of our government. There was a question about US aid and US refugee admissions program. I mean, I think clearly the impact of US aid is going to be tremendous. I'm not sure about directly in relation to questions around refugee, but not only US aid, but all forms of US assistance particularly to developing countries is going to have a huge effect on a number of countries, including South Africa. I mean, just for example, a lot of our medical research is funded through American sources, which seem to be in the process of being cut out, apart from the PEPFAR program itself and various other really important things. And as far as US refugee admissions program is concerned, and US migration management is concerned in general, I hope nobody else in the world, follows their examples, their current examples, where they are doing things which are illegal. They're being challenged by their own courts, and they are behaving in a way that is very destructive, I think. I mean, if they were to carry out the removal of all undocumented migrants from the city of Los Angeles, the city of Los Angeles would fall apart. It's half of the labor force, effectively, in Los Angeles. So they're doing things that are impractical, inhumane, and a little bit crazy. And I'm sure that we won't be following their example in any significant respect. So thanks again for being part of this process, and to all the other participants.
Thank you very much, Ellen. And thank you to everyone who joined us today on this important dialogue hosted by SALO. We're deeply grateful to all our panelists for their valuable insights and engaging very thoughtfully on these complex policy and human rights issues, which is at the heart of South Africa's migration landscape. As we've heard, these policy shifts could significantly change and shape the lives of migrant refugees and asylum seekers, as well as the country's broader human rights framework and democratic principles. As SALO, we always remain committed to providing inclusive multi-stakeholder spaces where government, civil society, researchers, and affected communities can come together to engage constructively. Dialogues such as today are extremely important, especially in giving the evidence-based policy of centering dignity, justice, and humanity in all the space aspects of governance. Thank you again once for all your time and all your valuable contribution and our ongoing commitment to be building a more just, inclusive society. We look forward to welcoming you to all of SALO's future dialogues. Thank you very much.
Thank you all, and goodbye.
Thank you.
Thank you, Busi.
Bye-bye.
Thank you. Bye.